Okay, well, I think we will get started, and as other folks show up, they can join us. Had a little bit of technical issues on my end here, so I'm just going to be the floating voice out in the ether for you today. Good morning. My name is Brenda Schaefer-Pelnin. I am a planner with the Arrowhead Agency on Aging. I'd like to welcome you and thank you for joining us for today's session, Advanced Planning 101. Before we start, just a few housekeeping items. Today's session will be recorded to share on our Arrowhead Area Agency on Aging YouTube channel. I encourage you to subscribe to our channel so that you're able to keep up with the latest additions to our video library. We are always looking for suggestions for future webinar topics. So if you have something you want to learn about, some suggestions for topics or speakers, please feel free to send those to me at my email, which I will share in the chat in a moment. Please keep your microphones set to mute. Just a logistics note, if you experience issues with your bandwidth or audio quality, it may help to save maybe Steve. If you'd like, you can enter your first name and organization or community that you're from in the chat box. So can we get an idea of who's out there and what you're hoping to get out of today's session, how you found out about it. If you do have any questions during today's session, please feel free to either raise your virtual hand or enter your question in the chat and we'll address them. We'll also take some additional questions at the end of the presentation. Quick reminder to visit our Facebook page for more information about other upcoming sessions such as renters' rights, both subsidized and market rate, spending to public programs, and dementia conversations. You can also check out our website at arrowheadaging.org. Just a reminder again, if everyone can make sure that your mic's muted, please.
ProCare HR.
I'm going to go through and mute some people. All right. Well, we are lucky to be joined today by Kristen, today's presenter. Kristen is the managing attorney of the Duluth Office of Legal Aid Service of Minnesota and specializes in elder law and has for 20 years. Graduated from Mitchell Hamlin College of Law in 2001. Kristen lives in her childhood hometown of Esco, Minnesota, where she and her family raise cows and chickens for fun. Kristen, thank you for being with us today. I will turn things over to you.
Thank you very much, Brenda, and thank you to the ARDC for putting this together with me. And thank you all for joining. I think this will be hopefully a very good presentation. It's Advanced Planning 101, so there's a lot that we could talk about, but I want to at least touch on the main points that will be relevant for everybody for certain, but there are some things that we could dive into for more specific situations. For those, I invite everybody to contact us. We can have an individual meeting if you need. So with that, Brenda, would you please share the slides? And we'll get started. All righty. So next slide, please. So just a little bit about who I am and where I come from. Like I said, if you've got individual questions that you'd like to go into more depth, we are funded by the Older Americans Act, which is a special set of funds that help people who are 60 years of older. And we don't have the same asset and income guidelines that we do in our normal under 60, or not say normal, the under 60 legal aid, this traditional legal aid funding eligibility that you may be familiar with. So everybody 60 and over should call us because we can talk about this stuff with you. As long as you live in our service area, which you see in the yellow there. So interestingly, that service area is about 28,000 square miles, which is about the size of Ireland, which is an amazing fact to me. We only have a few offices and we have a handful of lawyers and we try to help as many people as possible. But this is one of the ways that we can do that, get the information out to people because knowledge is power. And we want to help people feel more powerful in their lives, which is exactly what advanced planning does for folks. So next slide, please. So today I'd like to cover 3 main areas about advanced planning. We're going to learn what it is and why you should do it, who should do it, and how you actually do it. In general, the why is because you'll be able to control your life when you cannot speak for yourself or understand your options. So you put things into place early while you can, so then later it's there. And we'll learn who should do it and who would be good candidates to fill those roles to step into your shoes. And the how of it is the legal documents. And we'll cover key legal documents that everybody should have. There's the Healthcare Directive, Power of Attorney, and I threw an extra one in there called the Transfer on Death Deed, because a lot of folks have houses. But there are other documents that we'll touch on as well. And we can do the next slide and you can see the list of the documents that we'll talk about. So Healthcare Directive, Power of Attorney, the 2 main ones everybody should have, but there's also a trust, transfer on death deeds, payable and transferable on death beneficiary designations, and wills. Those are the players in the legal documents that might be able to help you in your situation. Certainly the Healthcare Directive, Power of Attorney is helpful for everybody because you've got your own body and your own person and you've got stuff. And we can look at the next slide. And that's what I already jumped ahead and said that. So Healthcare Directive and Power of Attorney. So what is advanced planning? It's putting things in place in advance. It's so your wishes and goals are met when you cannot make decisions when you're older or anything happens. You could get hit by a bus and be in a coma. That could happen to me, and I'm 50. So if I don't have things in place now, somebody have to go to court and get a guardianship or conservatorship over me. I don't want that because that's a hassle. So if I have documents in place, like a Healthcare Directive and a Power of Attorney, that can give authority to my trusted people to act for me. So I keep control over my decisions. Next slide, please. So as we talked about a little bit more, you keep control. And how do you keep control? It's because these documents are legal documents and they have authority. If somebody is using them and somebody doesn't follow them, there's legal consequences. There's options that you can use to enforce them. For example, if you have a power of attorney and it's valid on its face, and your person who's stepping into your shoes, your agent, goes to the bank and shows them your power of attorney and it's valid on its face, the bank has to follow it. If they don't, there's certain repercussions that could happen. Your person could start a lawsuit, for example, things of that nature. So legal documents have power and you will preempt unwanted outcomes. So you continue to be able to voice your decisions, but just through another person. You avoid guardianship and conservatorship. That's a biggie. If you don't have a healthcare directive, somebody may have to go get a guardianship. If you don't have a power of attorney, somebody may have to go get a conservatorship. So guardianship is over your body, your person, where you live, your treatment options, healthcare, that sort of thing. Power of attorney and conservatorship is over your finances and property. It also covers your private information, non-medical information. Advanced planning also helps you ensure that after you die, your estate goes where you want it to go. You can do that different ways, and I'll show you. You can do it through a will, or you can do it through ways that avoid probate. And finally, the most important reason is it makes it easier for your loved ones. A lot of people tell me it's really like a gift to know what your loved one wants in those circumstances. So you don't have to guess what they want. In reality, there's always going to be some guesswork involved, but if you have conversations with people about what you want, they don't have to guess as much. And certainly if you have main things in writing, that will be a guiding light for them so they can make the decisions the best that they can in the way that they believe you would have wanted them to be made. It takes away any guilt they might have in making decisions. So advanced planning is really critical for people, especially as you get into the long middle of your life, and especially at the end when you may not be able to make the decisions that you once were. Next slide. And people might be surprised by this, but who should do advanced planning? Anybody who's 18 or older should do that. Because like I said before, everybody has a person and they have their own goals and plans in life, and they have their own stuff and their own private information. So everybody should. Once you become an adult and have the ability to contract, something to do. So it's not just the people in the middle and in the later stages of life, it's for everybody. You might have heard about the people, there's a college, a son who was in college and he died. The parents weren't able to get any information or get any authority to do anything with his things without going to court. I'm thinking of the iPhone case. So we're not going to talk about it today, but there is also power of attorney for digital matters as well. We're not going to, that gets too much in the weeds. We're not going to go there, but that's another legal document for another day. The next slide. But especially advanced planning is for folks that fit the situation on the right-hand side of this slide. If you're unmarried, you definitely want to have these documents: Healthcare Directive, power of attorney, and a will. If you don't have any close family or you don't want certain family to have control, you certainly want to put somebody in place that would bypass any statutory authority they might have. If you're in a second marriage and you have children from the first marriage, you should have these documents, because it's sometimes happens where everything is fine in the second marriage, but then if you become incapacitated, the adult children from your prior marriage might not like your current partner, and that's the time where they might try to assert their will over your will, what your desires are. So they will be fighting with your partner. So if you want your partner to have some authority, then you should have these documents. If you've received a diagnosis, that is definitely a good time to do some planning, especially with the Healthcare Directive. And if you want something different than the standard with the statutory rules, for example, thinking of wills, a lot of folks want everything to be split equally amongst their children. That's the standard. That's in the intestate statute. But if you want your estate to be split unevenly, or if you want it to go to charity, then you want to do some planning ahead and put that in writing in a will or some other arrangements. And we'll talk about that. Next slide. I want to get to the document, so I feel like I'm going a little bit too fast. So if you think I'm going too fast, please feel free to ask questions. I want to answer any that come up, because if you're thinking them, somebody else is too. So now that you decided, hopefully, that you should have some of these documents, who makes a good candidate? In general, who would be there for you in an emergency? Who would be there for you at your hospital bed or your bedside? Picture them in your head. Of that group, What are their strengths? What are their ability? Are they willing to act for you? Are they trustworthy? They do not have to live near you. It's handy if they are, but it's not necessary. Many things can be done digitally or virtually, remotely. So it's not necessary to have them live in the same town or even the same state. It's better if they are because you can communicate sometimes better, but it's not necessary. So what roles suit them? For example, things that a healthcare agent might do for you are different than a power of attorney agent would do. Some people are more suited for different roles. For example, for a healthcare directive, I've got my husband as my primary, but I've got my mom as a secondary, and not my brother, because he doesn't necessarily like the hospital situation where my mom is. So she used to work in the medical field. So she doesn't have the white coats. She's not afraid to talk to doctors about what I want. So you want somebody who's not afraid to stand up for what you want. But on the other hand, my brother would be an excellent choice for a power of attorney because he's excellent with paperwork and all that other financial things. So he would be a good choice as a backup. So think about those things and pick from those, and then go ask them. Ask them if they're willing to do that for you. It doesn't make any sense to put all the effort into making your documents if they're not willing to act in the first place. You can't force them. But maybe one of the most important ones is, are they trustworthy, especially for power of attorney? As we'll see, having a power of attorney is a very powerful document, but it makes it very easy for somebody to steal from you if you don't have a trustworthy person. So think about all those things and pick a few and go talk to them and have a conversation. And then we're off to the next slide. Yeah, now we're to the how. So this is what probably most people wanted to talk about. So we're going to look at legal documents and things to communicate and think about with legal documents. So let's go to the next slide. So number one, it would be ideal to have an attorney to draft these documents for you, but you don't need one. You can do it on your own. I know you can. You might think it's too complicated, but you can. I don't think I'm telling tales out of school, but sometimes lawyers like to think things are tricky. These aren't tricky to draft. If you know what you want to put on them, it's easy. The mechanics of doing it, it's just filling out a form and signing it correctly, and then doing the next step, putting it where it needs to be in the right spot. That's all there is to these documents. So what I want to do is to show you them so you know what they look like and what to think about, so you have an idea of what choices to make on the documents. What lawyers can do for you the best is to help you make the choices, fit your goals. So that's what I want to do today. So next screen, please.
Because right now in your office, she's going through what she is going through.
She had a panic attack.
So first, the first step you will do is you will try to client. Second, then you can do like normalize her reaction. Third, you can do education. This is how we talked about immediately. So right now, the most important thing that you do, you try to ground the client what is happening in and here. So you will see from wherever she's
And
going and whatever is.
Yes, ma'am.
I don't mean to interrupt, and I want to answer your question, but I'm only getting every word.
20. A 4-year-old brought in mother who anxiously tells the therapist that she thinks her son has been molested. When the therapist asks what makes her at this, starts crying, tells the therapist that she has caught him masturbating in his bed and in the bathtub. The therapist should first ask the child if anyone has touched him in his private place, validate the mother's concerns, and utilize the therapist to assess for sexual abuse. Get a release to talk to his school and find out if they have seen changes. Or provide the mother with education regarding his development stage.
I don't mean to,
And by his
I don't
mother.
want to, I don't want to interrupt again, but how about if the audio isn't okay, but I want to answer your question. Could you type it in the chat box and then I can get it added that way? If the audio is just not working and I can't hear the question well enough. But the chat box, if you could type it in there, I'd be happy to answer. And then if you don't want to do that, my contact information is going to be on one of the ending slides as well. So you can email me or call me too. But the chat box, I'm sorry, I can't, the audio is not working. And I can jump back and forth from the different parts of the topic too, so don't worry about that. So, and I thank you for your patience. I just couldn't hear. So the documents that are used during your life are the Healthcare Directive to control your body, what decisions are for your body, taking care of your body, and then power of attorney and trust to control your finances and property and your general private information. So a lot of people think power of attorney is just for property and finances, but that power of attorney document is critical for your agent to be able to get information from other entities. For example, a bank, an insurance company, anything. So they're not going to give your agent private information unless you've given them a power of attorney. So it's excellent to have, even if you don't think you have property that is going to be hard to handle, even if you're incapacitated. Everybody should have a power of attorney. I see a big rectangle on my screen. Do other people see that as well?
Yes, it's on my screen also.
Oh, now it's gone.
Yeah, it's gone.
We'll see if that's something to worry about later. And trusts. Trusts are special instructions that you have about assets that you put into a trust. There are many different types of trusts. The gist of it is that you transfer the title of an asset into the trust's name. You are named the trustee, the grantor and the trustee, because you're putting your stuff into the trust. And then you have successor beneficiaries or trustees when you die. That's the gist of a trust, but that's just the surface. There's many different types of trusts. They cover things when you're alive and when you're dead. And you can see the next slide. You'll see that come into play. So you can see that trusts are still around and useful for after you die. Healthcare Directive is as well, but only for a narrow purpose. So if your Healthcare Directive talks about what you want to have happen with your body, like organ donation, funeral instructions, your Healthcare Directive will still have authority for those purposes after you die. The other things that come into documents that come into play when you die are wills and the beneficiary forms, the payable on death and the transferable on death. So for example, you could go to your bank and ask for a payable on death beneficiary form, and then you could fill that out and name beneficiaries for your bank accounts. The beneficiaries have no ownership of that asset while you're alive. That only comes into play after you've died. Similar to a will doesn't have any effect until you die. So you can change it up until you die. Any questions so far? We'll go to the next slide.
I was just going to say, Della had a question about, is the POA only for a living person?
That is an excellent question. Power of attorney is only for living people. Once you die, it's automatically void. So at that point, if you needed something to handle, somebody to handle your finances, that would be where the will would come into place with a personal representative. Or if you have a small estate, then your people can do something called an affidavit for collection of personal property. A small estate is when you have your probate estate is $75,000 entitled personal property or less, and you have no real estate in your name only. So if you've got a bank account and a couple of cars in your name only, for example, but they don't go over 75,000, your estate doesn't have to go through probate to transfer those titles. You just have to do basically paperwork. It's an affidavit procedure. Bank accounts do the collection of personal property affidavit. The driver vehicle services has their own similar form. So that's what happens there. But you're right, power of attorney is only effective when you're alive. The healthcare directive might be effective after you're dead. The will comes into place after you're dead. And trust could straddle both time periods. So let's take a look at some legal documents. So I like to start with the healthcare directive because everybody's got their own body. So healthcare directives come in many different formats. So in lots of different forms. And you pick the one you like. There's the one that we're going to use today is the shortest form, but there's longer ones. So the more information you want to share with your healthcare providers and your agent, you use the longer ones, but you don't have to. You can make it very easy, very simple to do, but the parts are the same. There are 4 main parts. You identify yourself, of course. You pick your healthcare agent or agents, have instructions, and you sign it correctly. Those 2 middle ones, the number 2 and 3, your agent and instructions, you don't have to have both. So if you don't have anybody that you trust, that's okay. You can still just have instructions, and vice versa. If you don't want to put down instructions, but you want to name somebody and you're just going to have a conversation, that's better than nothing. So you can still do that. You don't have to have both agents and instructions, just have one or the other. But ideally, it's best to have both because your agent will do a better job for you if they have instructions that they can refer back to. And your healthcare providers can refer to that too and do a better job for you. So Minnesota, I like to say, I call it a napkin state for healthcare directives because you can take a napkin if you're out somewhere and you can write a healthcare directive on that and bring over people to sign as witnesses. And that's a valid healthcare directive, but that's not the best a person can do. So I invite everybody to use the forms. And then there's another tool, as you can see on the bottom of the screen. If you go to this website, minnesotalawhelp.org, they have a tool where they ask you questions and you type in the answers. And then at the end of that question series, it generates the healthcare directive for you. And then you just print it out. So while you're generating it, it's private, nobody can see it. The site doesn't save it. It's just a way for you to fill it out without having to get a form and handwrite a form out. So that's an option. But there's other forms out there as well. There's the University of Minnesota has the form. Just gonna see, I thought I had a slide with this. Oh yeah, it's later on in the slides, but University of Minnesota, the Minnesota Attorney General's office, but the Minnesota Board on Aging, their website, they also have the U of M's toolkit. They've got honoring choices, directives. So later on in my slides, there's links to all of these places. So you can go explore and see which form you like. But if you don't like any of them, you can, Minnesota says you can custom handwrite your own on a piece of paper or a napkin. But this website here in this slide is an easy way to do it. So we can move on to the next slide. So this is the Honoring Choices Healthcare Directives. It's the shortest one around. It's only one page, as you can see here. So what we have on the top says Wishes for Healthcare short form. So if you want to go look for that on their website, you can find it. But it's super, super short. You put your full name there, that's including your middle name and your date of birth. So with your date of birth, I recommend doing the full date. We'll look at this question really quick here. What is the difference between a post and a healthcare directive? My husband has complex health issues and I have a 90-year-old parents. That's a very good question. So post is basically order, a medical order. It's different than a healthcare directive in that healthcare directive isn't used until your doctor triggers it. Your doctor will trigger it when your doctor says you can no longer understand or communicate your healthcare wishes and options. Until that's triggered, the doctor and healthcare providers are going to ask you. So that brings you to the post, where a post's purpose is that they don't have to have that trigger and they don't have to ask you. So it was created so emergency personnel, the EMTs that come to your home, they don't have, if there's a post in place, they can follow it. You don't have to tell them, nobody has to ask what you want. There's your order made in conjunction with your doctor about what you want. A lot of times it's used for a do not resuscitate order, but there's other things in it as well. I didn't include it in here because it's more of a little bit more advanced form. So the people who have a post are those people who have a life expectancy of maybe a year or a shorter life expectancy. And that's where it's geared towards. So everybody should have a healthcare directive, but not everybody needs a post. But if you've got a health condition where your prognosis isn't good and you don't want EMTs, for example, to do life-saving work on you when they come, have a post and say so. You can also say the other things on the post, like intubation and those sorts of things. So I hope that answered the question. That was a good one. And the post travels with you, whereas a doctor order in the hospital really stays at the hospital, but a post travels wherever you are. So, healthcare directives. So everybody should have a healthcare directive. So when you're identifying yourself, use your full birth date, with the full year. I know, I was born in the 1900s, so I'm going to put 1971. Don't put your social security number on there. And the reason is because when you are done with a healthcare directive, you're going to give it to your clinic, your doctor. You can even have it filed at the hospital, and you don't know how many eyes are going to look at it. So you don't want to put your social security number on it. Social security numbers aren't supposed to be used for identifiers, but that's how it's evolved in our society. They don't need it. Your name and date of birth is enough. Let's see. Your healthcare directives were drafted in Georgia, where we're legal residents. Do snowbirds need one drafted in Minnesota as well? That is an excellent question as well. So healthcare directives in another state should be followed under the U.S. Constitution's Full Faith and Credit Act, but it's good to have the state's form that you live in. So I'm not saying get rid of the Georgia form. If you go to Georgia for part of the year, it's good to have their form with you. It's going to have less snafus down there to use than a Minnesota form. But I would recommend having a Minnesota form because you live in Minnesota and just have both forms. And then what you want to do is travel with them. So keep them on in your purse or suitcase or somewhere where somebody's going to find them. And then for somebody to, when you're traveling, they might not know you have it. The next time you go to the driver's license place in your town, you can have them put on the back of your driver's license that you have a healthcare directive. So if you were to get in a car accident, they can look and see that there is a healthcare directive and somebody's going to go looking for it. Until they know what your wishes are, of course, they're not going to look at a healthcare directive at a car accident. They're going to get you stable and get you to the hospital. Once you're stable, that's when the healthcare directive is going to be looked at if it's triggered, if you can't communicate. So good question. Then you can see on going back to the healthcare directive, after you identify yourself, the next thing is naming an agent or more than one. This form only gives you a chance to have 2 agents. So they have a primary and a backup agent. So you might not like that. So if you don't like that, get a different form because other forms have different ways to have it arranged. So and this is where you think about who would make a good agent. So for healthcare directives, a lot of people name their spouses or their partners, which is good. But then a doctor had said once to me, who's going to be in that car with you in that accident? A lot of times your partner or spouse is going to be there and they might be in the same shape that you are in and not able to act for you if it's needed. So that's why it's good to have another person as your agent, somebody who's not going to be riding in the car usually. So an adult child or another trusted relative or trusted friend or family member. They don't have to be family members. Sometimes people want to put their nurse or doctor as their agent. That's really kind of frowned upon and they're not going to want to do it. The only time you really do it is if your family member or is a doctor or nurse anyway. But then there are some forms where you have to explain that relationship. So the bottom line is your doctor and nurse, treating doctor and nurse aren't going to do that. So that's naming an agent. So if you didn't have instructions or you were not sure what to put down, you could skip that part and then go directly to the signing part. But let's go to the instructions part on number 2 here. It says I give following instructions about my healthcare, my values and beliefs, what I do and do not want, views about specific medical treatments or situations. And if you can see that if you need more space, you can write on the back. This is really not, this form is really not a spot where you get into a lot of detail. It's more for your philosophical views. So what I would suggest is think about what is worth living, what's important to you in life. So if you're not able to communicate and that's, for lack of better words, a deal breaker for you, then you could say, I want less treatment if I can't meaningfully communicate. And the likelihood of me being able to not meaningfully communicate, then I don't want as much treatment or something along those lines. Or the opposite, you could say, I want all treatment, or I want people to try things for a period of time and then get a sense of what the prognosis would be, or what's, it's more of a philosophical place to put things here. You'd see in other forms, you can talk about specific treatment, like intubation, dialysis, CPR, those sorts of things. So you can talk about times when those you would want or wouldn't want them, Other forms have things in there where you might think are silly, but make a better quality of life for you. So some of the things that you could put in your instructions, not in this little spot, but on an attached form or a worksheet or something, you could say all those daily things that your preference is for. So for example, if you really like a certain type of music, you can say, play this type of music. If I can't communicate, this is what I would like you to do. Read me this paper, or play this music. Don't play this music. Or I want to be able to see greenery, bring animals in. My preferred doctor, my preferred whatever. So those sorts of things in a more expanded form. This form is pretty short, but you can have that conversation with your agents too, so they know. And then you sign it. You sign it and date it. Sometimes people get really excited when they fill it out and they sign it without getting in front of a notary or two witnesses. So wait, get in front of those two folks, one of the, the notary or the two witnesses, and then sign it. And then what the notary, if you go to a notary, the notary fills out the notary block and puts their signature and stamps it. And then if you do the two witnesses route, then they'll have to sign where that is. You can see you need two witnesses. You can't have both witnesses be healthcare providers. So keep that in mind. And your agents can't be your witnesses. So that's a healthcare directive in a nutshell. It's not used until your doctor triggers it, but when it is used, they're going to look to it. It's a legal document, and they're going to follow it to the best of their ability. And if they don't, or they don't want to, then they have to make arrangements so it's able to be followed. And the question is, do two witnesses need to sign at the same time? The answer is, for here, yes, because they have to see you sign it. So other documents are a little bit stranger, but they don't have to sign at the same time. But this one, they should sign at the same time because you're only signing it once. So we can go on to the next slide. So what do you do with it? Like I said before, if you're traveling, you want to keep a copy with you at all times. At home, if you're not traveling, keep it with your important papers at home. Do not lock it away in a safety deposit box because you want to have it handy for a couple different reasons. The first reason is that there's going to be times where you might want to update it or change it. And it's really hard to change it if you have to get out of the house and go to the safety deposit box. You want to have it handy. Also, people need to find it. So if you didn't give a copy to your agents, which you don't have to, and you didn't give one to your doctor or the hospital, people need to find those things. So don't have it locked in the safety deposit box because nobody can get in it. And if you wanted to change it, it's really easy to change healthcare directive. The way you change it is by making a new one that automatically revokes the past one. That's why it's important to have a date on that healthcare directive. And there was a place to put a date on the form. So healthcare directives, copies are just as good as an original. So don't worry if you gave somebody the original. Copies are just as good. And I saw that there was there's a question here. Oh, yep, a statement. Short form is easier for people who have some cognitive impairment to complete. Otherwise, the long form is best. I agree, totally. So with any legal documents, when you're filling them out or somebody's filling them out, if they're struggling, you don't have to do it all in one setting, one sitting. You can break it up into manageable chunks. So maybe just getting the name and date down, just one little bit, and then come back to it later when they're fresher and have more cognitive ability at the time. That's a good point. And then we carry copies of healthcare directives, power of attorney, emergency contact. Excellent. Those are all things that I would recommend that you carry when you're traveling. Hospitals will take your healthcare directive. The local hospitals will, even if you're not a patient, at least St. Luke's and St. Mary's do. They'll scan them and have them on hand. Whenever you go to a hospital, they're going to ask you if you have a healthcare directive. And if you don't, they're going to ask you if you want one. So it's better to do them ahead of time so you have a chance to do it. Keep in mind, nobody can force you to have a healthcare directive. So if you don't want to do one, you don't have to. But I highly recommend it. And then that is it for healthcare directive. As people have questions, we can move on to the next one. If somebody thinks of a question, we can always jump back and forth. So where healthcare directives were about your health and your body, the flip side of the coin is power of attorney. So everybody should have a healthcare directive, should have a power of attorney for finances and property. So power of attorney, you're not giving up any of your rights. So I just want to, this is the main point. I want everybody to know you're not giving up any of your own authority. You're sharing it with somebody. So you still call the shots. Sometimes in my practice, though, I've seen some adult children think that they call the shots because they're the power of attorney. That's not the way it is. So they have a fiduciary duty to you to do what you want. And if they're not doing that and they're trying to take over your life, then you should think about revoking that power of attorney because they're not doing what you want. If you know, so that's just a big point. So you're not giving up anything. And here's a question. Also in healthcare direct, I gotta make sure I miss. Also with healthcare directive, it does not take effect until physician indicates, yep, that they can no longer make decisions. Yep, it's not triggered until that happens. With a power of attorney, however, once you sign a power of attorney, it's automatically valid and can be used right away. There's no trigger for the power of attorney that I'm going to show you. Now, you can make your own custom-made power of attorney that has triggers in it. So we would call them a springing power of attorney because it doesn't spring to life until something happens. So with the statutory short form power of attorney that we're going to talk about, there's no trigger, there's no springing power. It's automatically already sprung. It can be used, even if you have all the capacity in the world to do your stuff right now. But all power of attorneys have this 7 main parts. So you identify yourself just like all of the legal documents. You pick your agent. On this document, they're called attorneys in fact. That's just a term. Don't get thrown by it. Just means your agent. Sometimes people say, who's your power of attorney? What they're really saying is, who's your agent? Who's your attorney in fact? You share powers, your authority. You choose whether you allow transfers to your attorney in fact, or whether you don't want that to happen. What kind of accounting you want them to do for you. That's basically saying, show me what you've done for me. That's what an accounting is. And then you sign it correctly, which is in front of a notary. And then there's some notices that both you as the principal read and your attorney in fact read. The notices are just there as a safeguard for people to be on the same page of what a power of attorney is, what everybody's roles are, that sort of thing. So we can move on to the next slide. So like a healthcare directive, later on in the slides, I have links for other versions of the statutory short form. But keep in mind, it's got to look like this. All the stuff has to be the same. The top part, the font, that sort of thing, that can all be changed. But the basic things in it has to be the same. Otherwise, you've created a common law power of attorney. You might ask, why does it matter? It matters because the statutory form comes with a whole chapter of statutes And in that chapter, there's a bunch of enforcement statutes. So if you make it into a common law power of attorney, you're giving up those statutory enforcement laws that could be beneficial for you. And then you're left with the case law type of enforcement, which isn't terrible, but don't do it. If you want to have a common law power of attorney, you can have both at the same time. We'll talk about why it might be a good idea or not. But for this, for everybody's purposes, that everybody should have the statutory short form because it's recognizable across the state. Everybody knows it. It's easy to do. You just fill in the blanks, check off boxes, sign it, and give it to where it's supposed to be. So it's easy. And it comes with all that statutory enforcement. So on the top here, don't worry about that where it says this note will not print on a completed document. This form I got from the Minnesota Department of Commerce. They have a section of forms called uniform conveyancing blanks. It's just a fancy name for forms people can use. And everybody recognizes them. They come with a number on their form 100.1.1. Easy to find. So when this blank part is, so if you were to use your power of attorney to do real estate work, you need to file a copy. You need to file an original power of attorney with that. So that's where all the county recorder stamps would go. There's a question here, would power of attorney be valid out of state? That is a good question. I would make an argument that it is under the Constitution. But judging by some hassle people have had with different banks out of state, I would recommend if you spend a lot of time in a certain state to have their statutory power of attorney too. So I wouldn't do that unless you really were going there every year for an extended period of time. Otherwise, you should be fine with the Minnesota form. So this is the Department of Commerce's form. Everybody uses it. Attorneys use it. This is the one I draft for people when I draft for folks. And you are the principal, so you identify yourself. So you put your name, address. You don't have to put your phone number. Attorney in fact, you can see on the left-hand column, that's where you list your people who you want in that role. You can have more than one person here. So, for example, if you want to name your spouse or partner here, but also have somebody that has equal footing and maybe an adult child you can have here. This might come in handy if your spouse or partner has a diagnosis where at some point in the future, they might not be able to take on the role of being your attorney in fact. So you could in advance put another person in the same position. You can see on the right, it says successor attorneys in fact. This is optional. So you can have backups. These are just backup people when the attorney in fact aren't able or aren't around to act. So they can step in and do some acts for you. If you have more than one primary attorney in fact, on the bottom left, you have to choose whether you want them to act independently of one another or if you want them to act jointly. So this is where you decide, do you trust your primary agents enough to act independently or not? If you don't, then you want them to act jointly. Jointly means that they have to sign every document. Both of them have to sign. So if they were going to write a check off of your checking account, for example, they would both have to sign, which can be cumbersome, but it's doable. And speaking of signing, the correct way of signing as a power of attorney for somebody is to say you write the principal's name and then comma by your name as people you can say attorney in fact or principal or power of attorney. That will show the intent that you're signing as the principal and not yourself. So you don't become personally liable for any contract you're signing. Also on this first page is expiration date. You don't want to leave this blank. If this is for planning into the future, I write none. So there's no, it's clearly intended that there's no expiration date. So it will continue on until either you pass away or you revoke it. And then we can move on to the next slide. So there's only 5 pages on a power of attorney, so don't worry. It's not going to be too rough. This second page looks like a lot, but really this page just covers powers that you're sharing and whether or not you want it to be durable. So under the first, where it says first, this lists different powers, A through N. So these are the different things that people use power of attorney for. So you can see that there's real estate actions, there's personal property transactions, there's bonds, trusts, and any type of business, there's insurance, beneficiary transactions, gifts, fiduciary, all kinds of stuff. Benefits from military service, records, work reports, and statements. So this is so if people want to use a power of attorney for just one discrete action, they can pick a discrete power to share. But for planning purposes, you don't know what your agent is going to need it for. So I would recommend that you choose in all of the powers listed above. So they are able to handle anything that may come up for you. You can, it's pretty small, but you can see that it says other than healthcare decisions under Healthcare Directive. So this was put in so it makes it clear that a power of attorney covers property, finances, information, and not healthcare. And this under second is where you make it durable. By choosing the first one, it says shall continue to be effective if I become incapacitated. And that's the whole shooting match. That's what you want it for, because you want them to be able to step into your shoes if you become incapacitated. So you want to check off the first one. That's what people mean when you hear them saying it's a durable power of attorney. Now we can go on to the next slide. So this is the trickiest page to explain. So under the third paragraph is where we talk about transfers to attorneys in fact. So what a transfer is basically putting an asset into their name, gifting to them. So you have to make a decision whether you authorize that to happen or not. If you do, you have to check the second line and write their name down. Without that, they're not going to be able to put things from your name into their name. Maybe you don't even want that to happen, but sometimes people, if they have a habit of giving gifts, like for Christmas time, and they want that practice to continue, for example, even if they're incapacitated, their attorney in fact can't do that to themselves or somebody they have a duty to support unless you authorize it. So the people that an attorney in fact have a duty to support are your grandkids if you've named your child as your attorney in fact. So you want to keep that in mind. If you have a practice of gifting and you want your child to be able to continue to do that, you should authorize that on the form. That said, it's easy for people to steal that way. So they just put it into their name and off they go. So keep that in mind as well. The limit, there's one more thing to keep in mind is the limit of the amount that they could transfer into their name or to somebody else's. And that's tied to the IRS limit, which is $15,000 per year. So if you were really rich, this is where you want to have a common law power of attorney. Most people get by just fine, the statutory short form, but it's not bad to have a common law. Certainly if you win the lottery, you want to have another power of attorney. So that might be as clear as mud. If anybody has questions about that, we can talk about it more. But the last thing to decide is what kind of accountings that you want your attorney in fact to give to you to show you what they've been doing on your behalf. So the first line says they don't have to render an accounting unless you ask it. The second line says, I want them to give me an accounting on a particular basis, like either every month, every quarter, every year, that sort of thing. So if you don't trust your agent, you want to build in an accounting that they have to do. If you're okay, maybe you're just fine with checking the first line. You get an accounting when it's asked, when you ask it of them. You might mind if you trust your agent, your attorney in fact, maybe when it's kind of a hassle for them to do an accounting every year or every month to say, I didn't do anything, because maybe they're not going to use it for years. And you want to have them give you a note, I didn't use it, RIP. You might turn a willing attorney in fact into a non-willing attorney in fact. But there's a balance. Find the balance that works for you. It's not bad to have an accounting on a regular basis, but I don't suggest every month. And then you sign it in front of a notary. So the middle there says signature of principal. That's you. You're the principal of your document. And then the notary fills out all the bottom and puts their stamp. I had a situation one time where a married couple used the same power of attorney for themselves, so they thought they could both be the principal, but that's not, you can't do that. Every person has to have their own legal document because you're your own person. So don't share a document, you got to do each your own. And then we can go to the next. So this is the last signature spot. So this is where your attorneys in fact sign. So this is kind of strange. They have to sign two places. They have to sign that they read the notice to attorneys in fact, that's on the last page. And then they have to sign a specimen signature. So you might think, well, why don't they just sign once? I think it's because the notice stuff is new. That was put in there in the early 2000s. And the specimen signature has always been there. So I think they just added it on. The specimen signature was there as a safeguard. So if somebody was pretending to be your attorney in fact, they can compare their signature to the one on the document. And then the notice signature is that they've read the notice, so they know what their duties are. For attorney in fact. So in two places, they don't need to sign in front of a notary. And that can be done later. They do not have to be there while you sign as the principal. There's on the left-hand side, this instrument was drafted by, that's the draft person's box. You have to have that filled in. So whoever fills in the form puts their name and address there. And the reason why you want it to be filled out is that if you ever need real estate work done by your attorney in fact, you have to file a power of attorney. Nothing can be filed with the county recorders unless it's got a draft person's box filled up. You gotta put that in. And it's also handy so you can go back if it's ever lost. Maybe the person who drafted it might have a copy. But speaking of copies, for power of attorneys, this is a legal document that I recommend that you do more than one original, because of the fact that if you ever need it for real estate, you're going to have to file that original. If you don't have original, then you have to make a certified copy, which is kind of a hassle. So prevent that hassle by filling out more than one original. I like to do, when I draft them, I look at whoever is named on the document, I make an original for everybody. And that just means you just sign a bunch at the same time. And then we can do the next page. Here's the last page. So here's where you can see where you would initial as a principal that you read the notice to you. We talked about all of that. So you already will be familiar with it. And then the notice to attorneys in fact, this is what they have to read. It's basically saying that they've got duties to you as a fiduciary and they're not supposed to take over your life. So that's what that is. That's power of attorney. It's a powerful document. It's easy to do. Think about what your goals are, what your practices are in your life, and how to have it so your attorney in fact can still do those things. So then we go to the next slide. So what do you do after you sign it? So you keep one original when you're important papers. And like I said, consider making more than one because copies are not as good. Don't give away originals unless you're filing one for an official purpose for the county. Only give copies to the bank, other places. Give copies to your attorney if you didn't make enough originals for everybody. Don't lock it away in your safety deposit box. You want it handy. You want to be able to get access to it if you have to either revoke it because you want to refer back to it, fill out the revocation form, or if you want to make changes to or make a new one. Then you want to make sure you can get rid of all the old ones. So that is a power of attorney. Now you can have more than one power of attorney in existence at once. Like I said, the common law power of attorney and the statutory power of attorney, but you can even have more than one statutory power of attorney in existence. So if you don't revoke a prior one, it's still valid. So and that can get dicey if you've got different attorneys in fact, and they're both trying to assert their power. So you want to keep track what's your power of attorney situation so you can make sure when you make a new one that you revoke the old one. And do a revocation for a power of attorney, it's more involved than a healthcare directive because you have to do a revocation form, sign it in front of a notary, and then give it to your old attorney in fact. The revocation isn't complete until they actual notice, so they have to get it. So you want to keep records of who you give things to. And that's the power of attorney. Any questions about powers of attorney? If not, look at the time here, we're doing good. So beneficiary forms are very nice to use. So this is where we're getting into what happens after death. So these forms help you after death and they help you avoid probate and keep things private. So and here's that tip about the small estate. So you want to put beneficiaries on assets, as many assets as you can. So then your probate estate can be limited to 75,000 or less with no real estate. So then you avoid probate. And probate's not the worst thing in the world, but a lot of my clients want to avoid it. So that's a big way of how to avoid it. Name beneficiaries. Beneficiaries don't control the asset, have no say in it while you're alive. You control it. And you can change beneficiaries at any time. So transfer death deed is for houses, real estate. Payable on death is for banks. Transfer on death is for like stocks and bonds, for stocks. So because a lot of people have a house, and this is, and a lot of people go through probate because they are the sole person named on a house. This is the way to avoid probate in that situation. You name a beneficiary on your real estate. So this form is from the Department of Commerce. You can see Ministry Uniform Conveyancing blank. Later, you can go look at other forms. It's the same thing. The date on it. You're the grantor because you're giving a beneficiary interest. And so you're here, but conveying and quit claiming the property to, and you got to put somebody's name here. And then the legal description. So it gives you the option to have more than one beneficiary. But if your purpose is to avoid probate, sometimes beneficiaries die before you. And if that happens and you have more than one beneficiary, it would have, the asset would go through probate anyway. So this sometimes is all, well, it's best used if you only have one beneficiary. But you can certainly have more than one. But if you have more than one, maybe that's a indication that you might want to check out other planning tools such as trust, so you can put more strings on it. The legal description, don't use the property tax statement because sometimes it's abbreviated. So you want to get out the current deed to your property and use that and just write it in there verbatim. Check this box if it's registered, also known as Torrens. You'd know that if you have a certificate for your property. Other properties are abstract, so you don't check that off if you have it abstract. Then we go to the next page. So then you check off this box where it conveys any and all interests in the property that you got either before or after on the date you sign it. This is just in case you found out that the legal description or something didn't cover everything. So you check that off. You sign it in front of a notary. Notary fills out the rest. You can see that draft person's box on the bottom, because you definitely want that filled out. Otherwise, the county recorder's office isn't going to accept it for filing. And that's all there is to naming beneficiary on real estate. A question pop up. So let's see. How does this work with medical assistance, and how does this differ from a life estate? Very good questions. We don't have time to answer all of them. I'm just going to put a plug in for a future presentation about medical assistance where we will cover that in depth. But in general, it differs from a life estate in that you retain full ownership. The transfer and death deed, you're not giving up any ownership interests. There is no life estate owner. There's no remainder interest owner. There's only you as the owner. So because there's no interest given, there's no gift problem for medical assistance. But that said, you don't protect the house either from a forced sale because there's a third party on title. So it's complicated. We'll talk about that in a future presentation. Good question. So we can go on to the next slide. So what do you do with the transfer and death deed? This is super important. You have to file it with the county recorder's office before you die. Otherwise, it's not effective. So all that work will be for nothing. So your house would have to go through probate if you're the sole person on it. So make sure if you do a transfer and death deed, the next step you do is you bring it to the county recorder's office and file it. And then let your beneficiary know or give them a copy. So then they can bring your death certificate to the county recorder's office upon your death. And then it's an automatic thing. They become the owner. So that's a nifty way to take care of a house with avoiding probate. We can go on to the next slide. So here we talk about wills. Let's check the time. Well, we got plenty of time. So testamentary documents are wills and trusts. So the purpose, like I said, is to make sure your stuff gets to where you want it to go. And you can give instructions and have strings attached. Trusts, you can have more strings attached than wills, but wills to a certain extent. Shouldn't be boilerplate off the shelf, one size fits all. It should be customized. We can go on to the next slide. So in Minnesota, a will is there's not a whole lot of requirements for a will. You have to, it has to be in writing in some fashion. Handwriting is fine, but typing is better. Now you have to be 18 or older to do one. You have to have a sound mind, which means you have to know in general what your estate is and what happens to it upon your death with this will. So you have to know what your will does, what you want to have happen to your stuff. And in Minnesota, the paperwork part of it, to be valid, it just has to be signed by you in front of 2 witnesses who also sign. Surprisingly, notarization is not required. But of course, you're going to see that in all the wills because that's a good safeguard. And of course, you would see wills that have a lot more language in it than just a 1-page thing. Because you can put language in there that makes it pretty much guaranteed to be safe from attacks that anybody that might want to contest the will. So there's certain language you can use. And then to make it even better to protect yourself, you should sign each page. Just put a line on the bottom, you sign it, and then of course put page numbers, because sometimes it's happened where people take a page out and slip in a different page. You don't want that to happen. A big tip is to mention that you have a tangible personal property list, or that you're going to have one. So then you can make a list at any point up until death and say, I want this person to get this grandfather clock or any type of personal property that you want them to have. And then the nice thing is that you can change that list at any time without having to do the whole formalities of signing. You can just make a new list and attach it. I recommend signing the list with a notary though, just so there's no arguments, but you wouldn't have to. You can change the will. Well, I just said that. Change your will up until death. Let's go to the next slide. So, because I think maybe not a lot of people actually see wills, might wonder what's in a will. So they have these parts. So of course, just like any document, you identify yourself, and you have language saying, I revoke all prior wills, and that I'm 18 years of age, sound mind. You're familiar with that. But then this is just the rest of it. There's going to be language saying that you want your debt taxes paid. That there's going to be, if you have special gifts that you want to go to certain people, you're going to say that in the next section. Like, I want the house to go to my 2 sons. And here's where you can put some instructions on it. You could say, if neither one wants to live there, I direct them to sell it and split the proceeds equally. Or if one son wants to stay there, he gets a chance to buy out the other before it's sold. Something like that. You can put some instructions with some gifts. And then you could talk about your tangible personal property list. But number 4, the residue. This is really, most of your stuff passes to your family through a residue clause. This is what happens to everything else that they have. So this is where people say, I want everything to go equally to my children, or something like that. Or if they want different, they would say, I want, because of lifetime gifts made to this child, I want this other child to get more, or I want something to go to charity. This is where you put that. You need personal representatives, and it says generally what they can do. You can have more than one. The court would approve those personal representatives. Just a tip, even if your will isn't going to be used, the fact that you would have a will with a personal representative named, your personal representative has the authority to wrap up your estate, even if there's no probate that's going to be filed. So it's handy if you've got a family that's going to be squabbling and fighting over getting stuff. So if you've got a will, it kind of puts that to rest right away, because your personal representative has a duty to safeguard and make sure that the estate goes where it should and has the authority to go along with it. So it's good to have, even if it ultimately the assets don't have to go through probate. But a will is used in probate if it does have to be used. So that's probably confusing. I'm just saying a will is good to stop family fights, if there's gonna be one. And then if necessary, a will to divvy up the stuff has to go through probate. For probate assets, for your probate estate. So then there's also going to be just government provisions, definitions, that sort of thing. Then if you have minors, you want to name guardians and conservators for them. And then you sign it, two witnesses, and the two witnesses sign. The two witnesses do not have to sign at the same time. They can sign later. So this is where it's a little bit weird. So they can, I don't know, they can watch you and then sign later. It's just kind of strange. There's a statute that says they can sign later. It's best practices to sign at the same time. Then there's that attestation clause. This is the self-proved language. This is that special language that makes it safe from people fighting over your will. So this is what a good will would have in it. It's not necessary. We can go to the next slide. So then what do you do with it after you sign it? You, as always, keep a copy with your important papers at home. And then I recommend filing the original with the courthouse before you die, because then it's stored there. Nobody's gonna read it because it's sealed. And it's handy, people can find it. Because you'll often find people thinking, I know that she had a will, but gosh, we can't find it anywhere in the house. If you've got it stored at the probate court, it's going to be able to be found. So, and there's a small fee for that, but it's well worth it, in my opinion. You can give a copy to others. You don't have to, especially if you want to think you can change it in the future. And that's what you do with a will. Trusts are different. A trust, you want to have everybody who's a trustee wants a trust. And then of course you want to have it in your important papers at home, and your trustees will have that trust as the rules of the game about how to handle those assets. Like a board game, top of the box of the board game, this is what happens in certain circumstances. And then just depends on what the trust is. Here's links to legal documents. So like I said, healthcare directives, there's many different forms out there. Pick the one that you like. Minnesota Board on Aging has 3 links to those 3 out there. Honoring Choices has some nifty ones. So does University of Minnesota, classic. Attorney General's Office has a nice bare bones one. Our lawhelpme.org has one. And of course, they got that it generates it for you link. There's also the 5 wishes are out there. People might be familiar with that. You can order that online. I don't recommend it because it costs you a few bucks. All these other ones are free. But you could take a look at it and see if you like some of the questions on there. Maybe you want to incorporate some of the things on there into yours. Nice to look around. But if you just want to get it done, I would recommend either the Honoring Choices short form or going to the lawhelpme.org and generating one. We can go on to the next slide. And then here's the final links to legal documents. So the statutory short form, you can go to the Minnesota Department of Commerce. I have the link there. And it's the form number is 100.1.1. Or to the minnesotalawhelp.org again. They've got a nice fact sheet and it has the power of attorney in it, plus the revocation form. So that's nice to get from there too. Transfer and death deed, again, Department of Commerce, minnesotalawhelp.org. For the Department of Commerce, it's in the 10s. The 10s are deeds, so you can find it there. And then Law Help with a nice fact sheet that goes along with the actual form. So check those out if you're so inclined. And then the next slide. And then I just want to say thank you to everybody. If you have questions, you can find me at this email address and this number. It's my work direct number. Texting is probably best just in case my voicemail gets full. But email is good. If you wanted to become a client, then you'd call our main number, which is 623-8100. We don't charge anything. We're a nonprofit law firm. And like I said, we serve people 60 years and up without income and asset guidelines, like the under 60s. And I also want to say thanks to Brenda Schaefer-Pellenin. She's the one handling the slides and helped out putting this together, and the Arrowhead Area Agency on Aging, ARDC, for this whole series and for funding our program. That's the Minnesota Board on Aging and the Arrowhead Area Agency on Aging. And I just want to also throw a shout out for Slides Carnival, where I found the slide deck. Any questions? I'd be happy to answer them now. And I see two.
Kristen, I'm going to cut you off real quick because we do have, unfortunately, we have another meeting that's coming in not too right after us and are waiting on deck for us. So I would say, you know, if anyone's got any additional questions, please feel free to reach out to Kristen. I will be sending out the slide deck as well as the recording, the link to the recording of today's session. Just a quick reminder, you can visit our Facebook page or our arrowheadaging.org website for more information about upcoming sessions, such as the one that Kristen mentioned on spending down to public programs. That's coming up in March. So check those out. But thank you so much, Kristen, for the wealth of information today and giving everybody a good foundation to start from in terms of looking at advanced planning. So thank you very much.
Thank you, everybody. And have a good rest of the day. And thanks, Brenda.
Bye. Talk to you soon.
Bye-bye.